All right, 25 minutes before 11 o'clock. Thank you for tuning in. John Fuller is here. It is July 29th, 2015. If that's the same date on your calendar, then you're listening to a live program, and your phone calls are invited. We welcome phone calls during John's appearance on the radio, simply so that he can answer your legal questions. The number is 622-9622-622-WOCA. Again, it is July 29th, Wednesday morning, on a beautiful Wednesday here in Ocala, Florida, and we haven't seen John in a while. Good morning, John.
Good morning, Larry. Good morning to the folks who are listening. We are happy to be back in your studio with you. July has kind of gone by like a blur, and like I was telling you before we went on the air, I had several out-of-town professional meetings and a short vacation squeezed in there that all of a sudden the month of July has gone by. So I hope you and all our listeners are having a nice and safe summer and enjoying our warm Florida weather, I guess.
Yeah. Do you know there was a story this morning about the father of the guy who shot and killed people in a movie theater out in Colorado? And the father was on the stand because he was pleading with the jury to not go for the death penalty. And I was thinking, well, that's the end of this trial, of course, but it's like all the technical stuff is now under the bridge, and it's just a matter of emotions, just to save. I mean,
I don't know anything about cases that aren't in federal court or not in Florida, because each state has different laws. But in a criminal trial, in Florida, we have a two-stage capital offense statute. If you're charged with first-degree murder with the state of Florida seeking the death penalty, you have a trial on the question of guilt or innocence. Then you come back after that and have a second part of the trial before the same jury on whether or not the jury recommends life imprisonment without parole or the death sentence. The jury recommendation in Florida is not binding on the judge. He may impose whatever sentence he sees fit. After the trial is over with, and at the time of sentencing, every defendant, no matter what he is charged with, is given an opportunity to speak to the court if he or she wishes. It's called a statement of allocution, or to bring in witnesses that may offer something that would have some bearing on the judge. And in some cases, people just want to go and express their affection for the defendant, no matter how heinous the crime. Family's family, and the law and the judge give them that right. Judges are not persuaded by sympathy per se. That's not an element or an issue that I'm aware of in any court. But the right to get up and say that as a parent, every citizen, even a convicted defendant, that's part of the process. And the judge may totally ignore it, but the person has had their chance to share. Sometimes, depending upon the circumstances and the nature of the offense, and I'm speaking from everything from the most simple battery all the way through the gamut of serious cases, obviously culminating with first-degree murder, multiple counts. You have, everybody has a right to say something. And I remember one time a very fine lawyer at a seminar I attended said, I always, first of all, if you're going to be the lawyer defending someone charged with a bad crime, you need to be able to try to find something of value about that human life in order to vigorously present the case. This is a matter of opinion, I'm sure. But if you can't, maybe you're not the right lawyer for the case. Public defenders I admire so much because they basically have to take everything, and they do a wonderful job.
Right.
But if nothing else, this guy said, you owe it to your client to make the best presentation at sentencing, even if you know in your heart that it's going to fall on deaf ears, because it may be the last time in his life that he hears anybody try to say anything good about him or her.
And we do have a phone call, John. Good morning. You're on the air. Thank you for calling, by the way. You're on there with John Fuller.
Good morning, Mr. Fuller. Always good to hear from you.
Good morning. It's good to talk to you. Yes, sir.
In regards to bond or bail or whatever you want to call it, is that always at the judge's discretion, or do they have perimeters, or is just solely at the judge's discretion?
Are you talking about statements at sentencing? Are you talking about statements at sentencing?
No, I'm talking about the bonds, when they set bonds, the bail bonds for people when they're sentenced.
Okay.
And they go before the judge to be, for somebody to bond them out. Is that totally at the discretion?
Are you talking about after they're arrested at the first bail hearing? Yes, that is in the discretion of the judge. They do have a bond schedule that most all judges follow, where depending upon the nature of the offense and the degree of the criminal case that they're charged with, and the number of counts, there is a presumptive bond schedule. However, our Constitution says that every accused shall be entitled to reasonable bail unless it is a capital offense, and then they're entitled to bail if the evidence of proof is not compelling or persuasive at the beginning of the case, and there's no danger of flight or harm to themselves or others, or that sort of thing. Judges can set bail at whatever they think's appropriate. You may have that revisited with a bail reduction hearing. And I have in the past, when I did a lot of criminal defense law, I have done that on many, many occasions, because at the first appearance, the judge may not have the opportunity to have all of the relevant facts presented to him. Later, shortly thereafter, you file a motion for reduction of bail, and you set a hearing, and the court may consider evidence that speaks to the constitutional question, is what is reasonable bail? If a person has very little assets or money, and you set $1 million bail amount on him, that is tantamount to no bail.
Yeah, right.
And denial of bail is a violation of the Constitution in cases that are not capital type cases, which is an exception. So you have to have reasonable bail. The elements that the court looks at is the nature and seriousness of the offense, the injury or damage to any alleged victim, the history of the defendant. Do they have a criminal record? Do they have ties to the community? Do they have family? Do they have a job? Have they ever been violent before? Are they a flight risk that they would flee the jurisdiction before their case came to trial? And if all of those things are answered, so that the judge is satisfied that whatever this person is charged with won't be repeated if he's out on bail, he or she. Number two, that they have ties to the community, they own a home, they have family here, they have a job, they've got there's vested interest, if you will, in staying here. They've hired a lawyer, they're presumed innocent, and what their finances are, and then set bail at an amount that's within reasonable reach of someone like that. So that's the best I can tell you.
We will take a little break and we'll be right back. Today is July 29th, 2015. If that's the same date on your calendar, then you're listening to a live show, and John Fuller is here to answer your legal questions. John, by the way, is from the law firm of Fuller and Fuller right here in Ocala. The show is called Legally Yours, and we'll be right back.
Here's what you may have missed on the John Tesh Radio Show.
When we buy a vacation, we're also buying a story. So even if the happiness bump from a vacation is long over, when we retell the story of how a pickpocket took our phone in Cabo, we get a happiness boost. Because with every sunburn, we're speeding up the skin aging process. When we skip the burns and apply sunscreen every day, we slow skin aging by up to 25%. Research shows that our biggest diet mistake is usually alcohol.
Intelligence for your life on the John Tesh Radio Show. Don't miss this stuff.
Good credits, bad credits. It's none of our business because we're not an auto dealer. We're not a bank. We're not your mother. We're OcalaForSale.com. Marion County's marketplace for cars, trucks, and SUVs. We've got thousands of sellers standing by to take your call. No middleman. But hurry, don't walk, don't run. Just sit down and log on to OcalaForSale.com. Prices and inventory change daily. Offer does not include dealer upcharge. Undercutting, rust-proofing, factory surcharge, or delivery fee. See website for details.
All right, 14 minutes before 11 o'clock. John Fuller is here. I have a question for you, John.
Sure.
What is the difference? I don't even know how to ask the question, but it's in the news all the time. Let's say somebody's in trouble for killing somebody, and now they're arguing as to whether it was a murder or a hate crime murder. The lawyers always seem to, the defendant lawyers always want the hate crime label to not be associated with it. Is it because hate crimes are a harder penalty?
Yeah, they have, and again, you have to read the statute, but they have different types of elements or different categories of crime that have enhanced sentences. Like a crime against an elderly person has an enhanced penalty.
Oh, really?
Yeah, if some young guy gets in a fight with another young guy and beats him up, that's assault and battery or maybe aggravated battery or what have you. If the young guy gets in a fight with someone who's considered an elder citizen and beats them up, then it's abuse of an elderly person, and that carries with it an enhanced sentence. They have all those statutes on it. If you have a case, you have to go look at the specific statute, because many of these statutes have come on the books in the recent past. And hate crimes are a separate category. I have not had one of those.
Oh, you have not?
And
I just don't understand. If somebody kills somebody, that seems pretty hateful right off the bat.
Well, if it's motivated towards against a certain class, if it's done, in that fashion, then that can be categorized as a hate crime.
And that's a harsher penalty because of
Yes.
what you just explained?
Yes.
Oh, wow. The phone lines are open if you want to call. The number is 622-WOCA, and John Fuller is here on July 29th.
I do want to take an opportunity to mention, since I haven't been here in a while, to remind folks that if they are in an automobile accident or they have some other type of accident with serious injuries, they need to talk to a lawyer immediately after the accident and not make a statement to anyone else but their lawyer.
Yeah.
And to do that, and of course we do that work at our law firm, Fuller and Fuller. And if you've been hurt or a member of your family or a loved one has serious injuries from an accident, feel free to give us a call. Our number is 352-547-4292. Our website is ocala-lawyer.com.
Okay, excellent. And we do have a phone call. Good morning. You're on the air with John Fuller.
Yes, good morning, Mr. Fuller.
Morning.
If a person does a crime in one state and is apprehended in another state, let's say across the country, and has to be transported back to the state where he did the crime, is that person eventually, does he have to pay for the amount of money involved in transporting him, or is that a taxpayer expense?
Well, I don't know about the answer to that in a specific case. I know that if someone is charged with a crime in one state and he's arrested in another, that state has procedures for extradition, they call it. and they extradite him back to stand trial. And I suppose it would depend upon the laws of the extraditing state as to whether that cost would be taxable. But I doubt it, because you have a right to a hearing for extradition. Some states have laws that if they're deemed against the public policy of the state of Florida, Florida may choose not to extradite that person. So you have a right constitutionally to have an extradition hearing. So those are not things that come along on a regular daily basis. So and it depends a lot on the extraditing state and the nature of the crime, whether the person was a fugitive from that or whether they live here and are a Florida citizen and the matter allegedly took place in another state. All of those things play into it.
Yeah, normally speaking, probably if the person that did a crime in another state, would the officials from the state that the crime was held, would they have to go and gather the person and bring him down, or
yes,
shipped by the state?
Yes, they have transportation services that transport people who are under arrest from prisons to prisons and from jails to jails, and they do this regularly. You may have seen them going down I-75, and they pick people up in one jail facility where they've been arrested and held, and if their trial is pending in another jurisdiction, they transport them to the jail in that jurisdiction if they remain incarcerated.
Okay, thank you very much.
Yes, sir. Thanks for calling.
The number again is 622-9622. If you want to talk to John. When you mentioned earlier not to say anything like to an insurance company after an accident, would that include don't say anything to the highway patrolman at the accident?
No, I'm sorry if I was overly general in that. Do not talk or make statements to any third parties. You have a duty to give information under the accident investigation privilege. If it's part of an accident investigation, it can't be used against you. If they think the accident investigation is changing into a criminal investigation, law enforcement is required to tell you that, and at that point your right to remain silent can be enacted. You need to cooperate with law enforcement. What I was talking about is don't talk to your friends, your neighbors, the insurance company for the other party.
Right,
they usually try to contact you immediately and ask for a recorded statement. And I think it's fair to say that they work for the other side, so they have a vested interest in the other side's point of view. So the good general information and recommendation is talk with your own lawyer first, and let him or her take care of that. You have a duty to put your own insurance company on notice, and you have a duty to cooperate with them. So certainly those are two exceptions. But if you make a statement to your next door neighbor or your hairdresser or your auto mechanic about how the accident happened and what hurt and what didn't hurt and how you're feeling and all those things, all those people could be called as witnesses against you. Well, I saw Jane Doe 3 days after the accident, and she told me she felt absolutely fantastic. No aches, no pains, no nothing. And then later she's claiming that she has injuries and damages. And some people just don't like to talk in public about their personal feelings. Some people are very stoic. And so if some third party says to you, "Hey, how you doing?" Well, that could just be a greeting like "Good morning," but and if the response is "I'm great, I'm feeling fine," well, is that an admission against interest that you don't have any pain or problems, or is that just simply that you don't want to share your personal physical feelings and well-being with the guy who's fixing your car?
Well, and that is exactly what happened to me. Now, it wasn't used against me, but I remember the other insurance company after an accident called me and said, "Good morning, Mr. Whitlam. How you doing?" I said, "Oh, good. How are you?" And then,
sure, they want to be your best friend then, and they want to get you to give a statement over the phone that they record.
Oh, really?
Yeah. Well, they have to tell you they're recording it if they do it legally properly. But those statements are often a few days after the accident, maybe before you've even had a chance to get thorough follow-up medical evaluation and treatment. You don't know what your legal rights are, and it's just not appropriate. And I don't know of anybody who would recommend that you do that. I think, what you need to do is you need to call a lawyer. I'm board certified in civil trial law and have been continuously since 1985, and someone who's knowledgeable, and see if you have a case, and most certainly if you have serious injuries or damages, it becomes even more critical, because once you hire a lawyer, then that lawyer can start doing things to preserve evidence. Go take photographs of both vehicles. Go take photographs of the scene.
Right.
Go get a traffic accident reconstruction expert in there to do the timing on the sequencing of the traffic control device. I just did that in a substantial case 6 months
really?
ago. Yes. It was a question about a left turn indicator, and my accident reconstruction expert was on the scene within 48 hours, had the city plans from the grid on what activated that traffic control device, and stood out there with a stopwatch and timed to make sure that it was in phase, in sequence, and was operating absolutely perfectly. And the only way my client could have possibly had the green light was if the other side had a left red turn error, which prohibited them from turning left, which unfortunately and tragically they did, and caused very substantial damages to my client.
So when a police officer determines that it's not just an accident, but there's a crime, does he read you your
that he is
Miranda
investigating? If the accident information that he gets in the accident investigation phase, which is privileged, which means what you say to them then cannot be used against you in a civil or criminal court case. But if that preliminary information leads him to believe that your conduct rises to the level of a criminal charge, and he then is investigating, going beyond asking the generic questions for the accident report, but is asking questions that are germane, and you are now a target or a suspect for a criminal investigation, then he has to tell you that Mr. So-and-so or Ms. So-and-so, I think that there may be evidence that this is a criminal case. I am now considering this a criminal investigation, at which point the individual may say, then I appreciate you telling me that and my rights to consult with a lawyer. I want to cooperate with you, but I'd like to take you up on what you just told me my rights are, and exercise those rights and talk to my lawyer, and we'll go from there.
That's scary stuff. Yeah. If it's a criminal case, but you are not implied as the criminal, in other words, let's say the other driver was driving drunk, it becomes a criminal case right then. But do you, as the victim, let's say, also have the right to just say nothing at that point?
Well, I don't think so. I think you have a duty under the statute. When you get your driver's license, there is a statutory duty that you fill out an accident report, and or that you give information for the investigation of an accident. So you have to do that.
John, the time went so fast. What is your phone number?
Okay, our office number is area code 352-547-4292. Our toll-free number is 855-534-2565. And you can get all this information and all about our law firm, Fuller & Fuller, at our website, which is ocala-lawyer.com.
Okay. John, good to see you again.
Good to see you. It's a pleasure. Thanks all our listeners and callers.
All right. We'll take a break and be right back.
Broadcasting from the Paddock Mall Studios, this is WOCA, Ocala, Gainesville, The Villages, 1370 AM, 96.3 FM, The Source.
Fox News Radio, I'm Pat.